Imagine this. After years of dedicated work, Dr. Nandini Rao's EB-1A Extraordinary Ability Petition is approved. The green card she worked so hard for is finally within reach for her entire family. But just weeks before the consular interview, a technical detail threatens to leave their teenage son behind. This situation is more common than many families realize. Today, Judith Marcelin, head of Casework and Compliance at the law offices of Chris M. Ingram, shares a real client story and explains exactly how families can protect their children in these challenging moments. We've put the questions and timestamps on screen so you can jump to what matters most to you. This breakdown is brought to you by the law offices of Chris M. Ingram.
Just a quick reminder, if you appreciate this kind of in-depth content, please take a moment to like and subscribe. It helps us bring you more content. Now, on with the video.
Employment-based green cards recognize individuals with extraordinary skills, advanced degrees, or exceptional talent. The EB-1A category, for example, is designed for those who demonstrate extraordinary ability in fields such as science, business, the arts, education, or athletics. When the principal applicant's petition is approved, certain family members, typically spouses and unmarried children under 21, may qualify as derivatives. These dependents can obtain green cards alongside the main applicant without filing separate petitions. Families have two main options to complete the process: adjustment of status inside the United States, or consular processing at a U.S. embassy or consulate abroad. Each path has different timelines, requirements, and strategic considerations. One of the most important protections for dependent children is the Child Status Protection Act, or CSPA. Passed in 2002, CSPA helps prevent children from aging out, losing eligibility the day they turn 21. The CSPA formula is straightforward. It subtracts the time a petition was pending from the child's age on the date a visa becomes available. The child must also take specific steps to acquire permanent residence within 1 year of visa availability. Visa availability is determined by the Department of State's monthly visa bulletin, specifically the final action date for the applicant's country and category. Understanding these dates is critical, especially for families from countries with backlogs.
Rome, 20,000 spectators, one epic battle, 2 warriors, one destiny. But before they can fight for glory, they must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
They should have went to the law offices of Chris M. Ingram. Off to the Lions pit.
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
In one real case, we handled Dr. Nandini Rao, an Indian national recognized for extraordinary ability in medical research, had her EB-1A petition approved. Her husband and teenage son, Veon, were included as derivatives. Their younger daughter, a US citizen, was already protected. However, while awaiting the immigrant visa interview at the US consulate in Mumbai, Veon turned 21. The consular officer initially denied his visa based on a disputed interpretation of the CSPA calculation and the exact date of visa availability. The family faced the real possibility of separation. When standard channels stall, a congressional inquiry can provide an important path forward. This is a formal request made through a US senator or representative asking the Department of State or USCIS to review a specific case. The process involves submitting a clear cover letter, supporting documents, and a signed Privacy Act release form. These inquiries often prompt agencies to provide a fresh review and detailed response, typically within 30 days. In the Rao family's case, Judith Marcelin and the team prepared a congressional inquiry through a senator's office. After careful review, the US Consulate in Mumbai re-examined the file. Veon's visa was ultimately approved, allowing the entire family to reunite and move forward together in the United States. To protect dependent children, we recommend the following. Monitor CSPA eligibility calculations early and regularly. Check the monthly visa bulletin carefully. Maintain complete, organised records of the family's immigration history. Respond promptly to any consular requests. Consider professional guidance when a child is approaching 21. Question 1. How long should I wait before contacting my congressperson about a CSPA or consular issue?
Wait until normal processing or supervisory review timelines have passed. Document all prior efforts first.
Question 2. Does a congressional inquiry guarantee a favourable outcome?
It does not guarantee approval, but it frequently leads to a fresh review and can resolve delays.
Question 3. What should I do if my child is about to age out during consular processing?
Act quickly. File required forms within 1 year of visa availability and consult experienced counsel to explore all options. At the law offices of Chris M. Ingram, we are committed to helping families navigate these complex situations with clarity and care. If your family faces similar challenges with dependent children or CSPA issues, we invite you to reach out for a confidential review. What questions do you have about protecting your children during the green card process? Share them in the comments below. Subscribe for more practical immigration guidance, and we look forward to supporting your family's journey.